The offer to purchase form states that a deposit of X amount forms part of the purchase price to be paid by the buyer to the seller. What happens if a deposit is promised in the offer to purchase and is not paid? A buyer may think that they will merely lose the ability to purchase that property. However, there are potentially some additional serious consequences to the buyer that they must be made aware of. If the promised deposit is not provided, the seller may decide that since the buyer breached a term of the contract, the agreement is ended. The seller may also take legal action against the buyer to claim the unpaid deposit plus other damages. For instance, if the property sells to someone else for less than was previously agreed to, the seller could sue the original buyer to require the original buyer to pay the difference. The original buyer may be sued for other losses the seller argues are related to the sale, including legal fees. The standard wording in the statutory residential or condominium offer to purchase is not clear on what would happen if a promised future deposit is not provided. The seller would likely have the right to take legal action, but what action and when that action can be taken is not clear. Even though a breach of the contract by the buyer has taken place prior to possession, the seller may take the position that they are entitled to claim the deposit as a debt owing and take additional action before or even after the possession date passes. However, some may argue that the failure to provide the promised deposit is a breach of a term that can only be acted upon by the seller, should the buyer not proceed with the transaction on possession day. Ultimately, the court may have to decide if the seller is entitled to compensation. Depending on timing, this could leave the seller with several days, or in some cases weeks or months, of uncertainty. This uncertainty could delay the seller from relisting the property or accepting another offer on the property until after the original possession date is passed. Direct your client to consult their own lawyer before making any decisions to avoid triggering unanticipated consequences. For any offer to purchase that states the deposit is to be provided later, advise your seller client to consider a counteroffer with wording that terminates the transaction if the deposit is not provided by a specific deadline and states that the seller has the right to sue for damages. This wording may not be suitable in all situations, and you should recommend your client discuss it with their lawyer first. You must be able to inform your buyer clients of possible consequences of defaulting on the offer to purchase, and that they may be held responsible for more than just the loss of the deposit. While there can be situations where the seller will extend the time for the buyer to provide the deposit, the seller is under no obligation to do so. If the buyer is late on delivering the deposit, the seller could decide that the transaction is terminated. Some buyers mistakenly believe that they do not have any contractual obligations to the seller if they do not provide a promised deposit. Remember, a contract is made when there is an accepted offer to purchase and when that acceptance has been communicated to the other party, not when the conditions are met.